In tonight's edition, more insights into the TRT stream of the 186 visa. The New Zealand invasion dwarfs the student visa arrivals. The new National Student Ombudsman's office opens its doors. An ANU study exposes some migration misconceptions. Questions about Peter Dutton's migration policy if he wins. And the new CSOL and the 186 direct entry scheme. And where did the poor childcare workers go to gain a skill assessment? Hi, I'm Karl Konrad and welcome to the weekly edition of Australian Immigration News. Not only have we crossed the 100,000 subscriber mark thanks to your help, we have also broken the 10 million views milestone. 20 million views, here we come. Tonight we are going to touch on some of the common issues which keep being asked regarding the TRT stream of the 186 Employer Nomination Scheme. For example, a question like this from Tulsi. Hey mate, I've heard rumours that when applying for the 186 Temporary Resident Transition Stream, we can use 2 years of work experience from any employers rather than the same current employer. Is that true? Well, the simple answer to that is yes, it is true. Most of you know by now about having to work 2 out of the last 3 years. When you apply for the TRT stream, you need to be on that 482 visa or one of the old 457 visas. It used to be that the 2 years had to be with the same sponsoring employer that is now sponsoring you for the 186 visa. Now you can have spent time with multiple employers, as the department's website indicates. If you have had multiple subclass 457 or 482 visas in the 3 years prior to your application, sponsoring employment can be counted in any occupation you have been approved to work in. If you have changed employers in the 3 years prior to your application, sponsored employment can be counted from the date an approved nomination was lodged if you started working with them before the nomination was approved. Typically, the unnoticed information here is sponsored employment can be counted in any occupation you were approved to work in. The department's policy documentation clarifies this further by stating, counting time when the occupation has changed. Where the visa applicant has changed occupation in the 3 years immediately before the application is made, time may still be counted if the employment was sponsored and there is a visa application that was granted in relation to the change of occupation. This means that you can count the time even if your occupation has changed, as long as the nomination was applied for was granted along with your new visa. This is because when an occupation change takes place, a new visa application must be made as well. If you are just changing employers and working in the same occupation, then there is no need for a new visa to be lodged, just a new nomination by the new sponsoring company. Do you have any questions regarding the transition stream? Let us know in the comments section. A recent report from the Immigration Department highlights that a whopping 1,786,486 Special Category New Zealand Subclass 444 visas were granted during the 2023 to 2024 financial year. In contrast, only 376,731 student visas were issued in the same period. It's frustrating that international students are often blamed for the housing crisis in Australia, especially when a significant number of New Zealanders move here, with many intending to stay long term. Given the working holiday makers also just reached record levels with just over 200,000 of them, can we please give up this notion that international students are to blame for everything? A significant new development for international students in Australia, the opening of the National Student Ombudsman's office, officially commenced operations on the 1st of February. The NSO, however, can only assist students who are studying higher education. Unfortunately, the NSO cannot assist vet sector students, which is rather disappointing. Of course, the Ombudsman's office is for all students studying in Australia and not just for international students. So what exactly does the NSO do? Well, they can investigate many things. For example, student safety and well-being, including gender-based violence, discrimination, racism, anti-Semitism, and Islamophobia. Also, student enrollment and exclusion issues. Student applications for special consideration, providers changing course structures, providers' complaint and appeal procedures, and the provider's failure to clearly explain their decisions. The opening of the NSO provides international students with a new, supportive avenue to resolve study-related issues without the fear of bias or repercussions. This is particularly helpful for students who feel their concerns aren't adequately addressed through the education provider's formal complaint process. Reaching out to the NSO is straightforward. International students can contact the office via their website, telephone, or in person. Now, being able to see a real person to discuss your concerns and make a complaint is a rare thing these days, so that is a big positive. A study by the Australian National University regarding Australians' perceptions of migrants was recently published. The study surveyed over 5,200 Australians and revealed some surprising misconceptions. Many respondents falsely believe that a large percentage of migrants in Australia are unemployed and that there are more migrants from the Pacific or Middle Eastern backgrounds than is actually the case. In fact, the survey found that people estimated unemployment amongst Australia's 8 million foreign residents to be 143% higher than the actual rate. In summary, the findings from this study highlights the importance of providing accurate information to shape public opinion on migration. By better understanding the costs and benefits associated with immigration, we can foster a more informed and constructive debate on the topic. I'll leave a link to the ANU article in the description of the video, and let us know your thoughts regarding these findings in the comments section. The Significant Investor Visa, commonly known as the SIV, was launched by the Australian Labor Government back in November 2012. It was later discontinued by the Albanese government in 2023. The initiative was aimed to strengthen the Australian economy by attracting high net worth individuals prepared to make substantial investments into the country. Applicants were required to invest a minimum of $5 million into approved investments. The decision to abolish the program was driven by various factors, including criticisms that it favoured specific industries over others and concerns that it did not align with Australia's broader immigration objective of attracting skilled migrants. Similarly, many EU countries have also ended their comparable programs, citing issues related to money laundering and security risks. However, all of that didn't seem to bother Peter Dutton, who recently seems in favour of bringing the visa back online.
Opposition leader is considering reviving a visa program which allows wealthy foreign investors a fast track into Australia.
9 News revealed the coalition is considering bringing back significant investor visas, popular with wealthy Chinese.
He needs to come clean. What's he been telling his donors about the visas that he will provide them if he is elected later this year?
That donor was migration agent Min Lee.
Behind a microphone, he says he's for less migration. When he's behind closed doors, he says he's for more.
So will Peter Dutton come clean on his migration plans for the country before the next election? No doubt there will be immense pressure to produce his plans and forecasts. It was no surprise that many lawyers and migration agents are eager for the program's reinstatement, given the substantial kickbacks amounting to tens of thousands of dollars they often receive from wealth fund managers when referring clients for the $5 million to be deposited. And these kickbacks are in addition to the already high service fees paid by the clients. What raises significant concerns is the reports indicating that some agents and lawyers fail to disclose that they receive such generous commissions to their clients. At the end of last year, the Consolidated Skilled Occupation List, known as the CSOL, came into effect, and many people were unaware that this change granted them access to the direct entry stream of the Permanent Residence Employee Nomination Visa, the 186. Various occupations were moved into the CSOL from the Short-Term Occupation List, which previously had no direct access to the 186 visa. Now, with the new list in place, access has opened up via the direct entry stream. Recently, we've spoken to several individuals working under the subclass 482 visa with nominations in the older short-term stream occupation list, who were surprised to realise they could apply for permanent residency directly and no longer had to wait to meet the transition stream requirements. To apply for the direct entry stream, all they need is a skill assessment, a minimum of 3 years work experience, and of course competent English. Many new occupations have made their way onto the CSOL that were not listed on the original subclass 482 short-term or long-term occupation lists. For example, childcare workers are now listed, which means they can not only obtain a new subclass 482 visa, but also access the direct entry stream of the subclass 186 visa. I highlight this occupation because we have received numerous comments regarding the challenges these individuals face in securing a skill assessment necessary for their permanent residency application. For example, Technoman wrote in and asked, "Hi Karl, my partner employer wants to sponsor her under the 186 direct entry stream. She works as a childcare worker, group leader, where we are waiting for the 3 years experience to apply for the 494 as we live in the Gold Coast. But with the new CSOL, she already has 3 years experience as a regular childcare worker. The problem we are experiencing is that she needs a skill assessment, but ASEQA is not doing skill assessment for regular childcare workers, so we are stuck with a skill in the CSOL, but no assessing authority willing to do the skill assessment. Do you have any information in regard to this topic? Thank you." The Australian Children's Education and Care Quality Authority, known as ASEQA, is the skill assessment authority for childcare workers. However, according to their website, there is currently no skill assessment process available for childcare workers, even though the federal government has designated their organisation as responsible for this assessment. Their website features skill assessment guidelines updated as recently as November last year. Yet childcare workers are notably absent from this documentation, and their website has not shown any developments as of this past Friday. This situation raises important questions. Is ASEQA intentionally denying childcare workers the opportunity to apply for permanent residency, or are they simply negligent in updating their skill assessment requirements? Is this another instance of a government organisation in Australia adopting a slow approach to migration-related matters? Regardless of their excuses, they are effectively blocking Australian childcare workers like Technoman's partner from applying for permanent residency by not providing the necessary skill assessment service for which they are approved. According to ANSCO, childcare workers only require a AQF Certificate 3 qualifications, whereas Group Leader requires a diploma. No doubt, like the Group Leader classification, only 1 year work experience will be required after obtaining the qualification. However, the role of ASEQA is to define whether applicants can apply. It's hard to believe that discussions didn't occur between the skill assessment body and the Immigration Department before the public release of this CSOL regarding ASEQA's role in assessing childcare workers. Yet, even months later, nothing has been done to facilitate these workers' access to permanent residency. We contacted ASEQA for comment, but as expected, they declined to provide one. Well, that's the end of another busy week here at the office. Remember, if you need help, we are always here. You can book a consultation online or just pick up the phone if you're in a hurry. As always, take care out there and I'll see you next time. So bye for now.